like to welcome you all here today and out in webinar land. My name is Joe Lynyak, and I'm going to be moderating this panel on blockchain and cryptocurrencies. As many of you know, in the last 5 years, you couldn't give a legal presentation without saying CFPB. Well, it's changed now, and you can't give a legal presentation without starting out in the first paragraph by saying blockchain. So we're going to be talking about that. It is the really hot topic. And as an agenda, we're going to be talking about concepts of blockchain coins and tokens. Then we're going to switch to what are the effect on these things with tax with Kim Severson, who's one of our tax partners. Then we're going to go on to SEC and CFTC laws and the Howey test with Tom Gorman, who is a SEC enforcement guy and defends against the cases brought by the SEC. And finally, what is really prominent, the ICOs and Regulation D offerings by Adrian Rich, who's a capital markets partner here at the firm. As you know, blockchain and cryptocurrency have created a frenzy. There's fraud and bad guys out there galore. There's an international investment bubble. So for those of you that have got kids that are investing in it, tell them they should watch what they should be spending. There's also a nomenclature disconnect in that the language being used over here in blockchain and cryptocurrency is not those things that we as lawyers use. And the sponsors of blockchains and cryptocurrencies, et cetera, they have eschewed traditional capital raising processes, and they're very similar to some of the crazies in the FinTech space that have said, listen, the rules just simply should not apply to us. And so we need to translate the fact that, yes, indeed, they do. Internationally, it's very, very uneven at the moment, where there's a lot of jurisdictions that have not made up their minds whether or not they should regulate regulate cryptocurrencies. And we are actually pretty far advanced, but we still got a ways to go. And in that regard, there's a number of state and federal initiatives that we will reference that are considering these topics. The premise of this presentation is that we as lawyers have got to deal with this brave new world, but we've also got to address and use traditional legal principles to give advice to folks. And that's really what this is going to be. Talking about blockchain, talking about cryptocurrencies, but applying disciplines that we're familiar with to help translate for our clients and friends what this really means, whether it's from a tax perspective or a securities law perspective or whatever. We've got FinTech issues, we've got IP issues, and we're going to try to touch on as many of these as we can within with the time permitted. Now, how confusing has it become? Well, it's become so confusing that 2 weeks ago, our friend John Oliver devoted his entire program to explaining what cryptocurrencies are. And I would suggest you may want to watch it. It's very, very funny, and actually, he was far ahead of a lot of folks in that he was wrong only about 50% of the time. So anyway, I would reference that. He's my hero. I watch him all the time. Now, quick background. What is blockchain and how is it different from other types of web applications? Well, the blockchain is a diversified ledger that's resident in literally thousands or millions of computers, and it records transactional data such as the ownership of an item, like a Bitcoin, the transfer of the same, and the possible transaction or function related to the item. It can be open or it can be a proprietary system, and people now, and a lot of folks in the office, in the audience here, are looking at those particular issues. Unlike data that can be placed on one computer and modified by changing the data on that computer, the blockchain collectively verifies the existence of an item, a function, or a transfer, and it cannot be altered except by the entire blockchain accepting the change. Now, what this means is you potentially eliminate the need for a verification authority, such as the Bank of Joe verifying the fact that the money came in and it was transferred over to me. And when you think about authorities that need to verify things, it creates the anonymity issue where you no longer need someone there saying, yes, I've received it. And that's an important concept. And as the panelists may be talking, well, maybe that's breaking down a little bit in terms of the anonymity, but that's one of the advantages, particularly if you're a criminal. Bitcoins and coins. The Bitcoin was the first decentralized cryptocurrency that resides on a blockchain ledger, and it's a substitute for fiat currency, which is a currency backed by the government that issues the currency itself. A coin is a variation of Bitcoin's open source code, and by altering the open source code, it can do different things, can have different characteristics, but right now there are over 4,000 coins in existence. And all the bad guys are issuing them on a daily basis, so you better be careful about what you buy or what your kids buy. Now a token, finally, a token is a secondary asset or application within a blockchain ecosystem, such as the Ethereum blockchain, which you may be reading about. It's becoming very, very popular, and it runs a secondary application on the blockchain system. And it can basically represent any asset which is fungible, tradable, from commodities to loyalty points, or even to other cryptocurrencies. And theoretically, it doesn't need a human being to run it. And you may have read about this as well, the possibility of creating so-called electronic contracts, where you don't need the verification authority to determine that the contract is being performed and transferring funds back and forth. So those are some basic issues. And by the way, blockchain and cryptocurrencies are really another form of FinTech. And for those of you in the banking field, we do FinTech all the time. We've done it all the time. There's mining contracts you've got to deal with. It's contracts. Innovative payment systems, which deals with potential of cryptocurrency. Counterparty agreements. IP issues are actually pretty specialized because the way that a lot of cryptocurrencies do their work is they issue what's known as a white paper saying, there's what I want to do. I want to create this new thing. Well, that may destroy the ability of being able to get it to have any IP protection because you're explaining what your innovation is. So it's kind of really curious. Now, we don't have time to talk about FinTech and IP today. But we're going to be posting on our website detailed discussions of these from previous presentations that we've made, and they will be available to you. Starting out now with Kim, question is tax considerations. And Kim, why don't you lead us through that?
Okay. So to start out, I think it's really important to focus on maybe three things. One is, even though this is very new technology with a lot of innovations and creativity and kind of a brave, new, and crazy world in some respects, the tax authorities have approached the whole area of cryptocurrency using very old, basic tax principles. And I think it is really correct to say that the tax principles that they are applying to cryptocurrency, starting with the IRS and presumably filtering down through the states, are the basic income tax principles that were created in the early decades of the income tax in the United States, so the first half of the 20th century. Second, it is important to remember that the way that these cryptocurrencies are treated for tax may be quite different from the way they're treated by other federal regulators. For example, I think Tom will tell you that the SEC treats these as securities. The IRS doesn't treat these as securities. And the third point is that people holding cryptocurrency are likely going to be quite surprised when they finally figure out what the tax people have to say about their gains and losses on cryptocurrencies. There is news that has been published in some of the tax sources that indicates that one IRS attorney has said publicly that in 2015, only 800 taxpayers reported Bitcoin transactions on their tax returns. There were probably a lot more than 800 people who had Bitcoin transactions. The IRS in 2014 issued a notice, which is a published official IRS position paper, that said that they were going to treat virtual currencies, and hold that thought for a minute, as property for U.S. tax purposes. What that means is that from the perspective of the Internal Revenue Service, cryptocurrency is not treated like U.S. dollars, and it's not treated like the currency of a non-U.S. government. It's treated like property, which means it's the same as if you sold a diamond ring, if you sold a house, if you sold a building, if you sold a car. The IRS guidance in 2014 goes through a lot of very basic concepts and results under the tax laws, but it is by its terms directed specifically to virtual currencies, which they define as cryptocurrencies that have an equivalent value in real currency. In other words, a US dollar value. Since 2014, there have been lots of developments and lots of new things in the world of cryptocurrency. I think one question that I have as a practitioner is whether that 2014 guidance from the IRS applies to everything, such as these tokens or other things that are being developed. I think the right position right now as a practitioner is to assume that, yes, what the IRS said in 2014 still applies to every kind of cryptocurrency unless you can show otherwise. Most of what I'll have to say today has to do with the IRS position on cryptocurrencies, but I think it's really important to remember that the states will also have positions on the taxation of cryptocurrencies. And somebody who's mining cryptocurrency, issuing cryptocurrency, selling it, could have state tax consequences. And in particular, those people should watch out for the states that are aggressive, have high tax rates, and are always on the cutting edge of state taxation, and that is California and New York. And Minnesota, same thing. We have a high tax rate, and our regulators in the Department of Revenue don't miss too many things. They usually follow New York and California. The surprise for holders of, actually stepping back, because cryptocurrency is treated as property for tax purposes, all of the regular rules in the income tax sphere that apply to dispositions and sales of property are going to apply. Somebody who holds an item of cryptocurrency and either sells it on an exchange for something that looks like money or is money, or uses that cryptocurrency to purchase something or to obtain services, is going to have a taxable event. When you have a taxable event, that means you can recognize gain or loss, and you will have a tax liability if you have gain. If the taxpayer sells an item of cryptocurrency on an exchange, that taxpayer will have gain or loss equal to the difference between the tax basis in the currency sold and the amount that the taxpayer realizes. Now, if we're talking about a cryptocurrency exchange, if I go out, if I have a Bitcoin and it has a basis of $10, and I'll get later to how you figure out what your basis is. My Bitcoin has a basis of $10. I sell it on an exchange for $100 US. I have $90 of taxable gain right then and there. No question about it. If I sell the same Bitcoin on that exchange for I don't know, Ethereum token, and the Ethereum token is worth $100 on that day, I have $90 of taxable gain. There's no such thing as a tax-free exchange of a Bitcoin for Ethereum or Bitcoin for Bitcoin. If I sell my $10 basis Bitcoin for a Bitcoin worth $100, I have $90 of gain. If I take my Bitcoin with a $10 basis and I go to the bakery and I submit the Bitcoin and the baker gives me a loaf of bread that has a sale price of $5, I have a $5 loss. But does that mean I can take that $5 loss and offset it against my wages on my tax return? Probably not. I mean, it depends. There's a lot of limitations on the loss. If I take my $10 Bitcoin with me to the veterinarian and the veterinarian gives my dog a rabies shot, the rabies shot normally costs $100. I've got $90 of gain, and the veterinarian has $100 of income, and he owns now a Bitcoin with a basis of $100. So all of those transactions have consequences. The tax basis of the Bitcoin is really important, and this is an area where there is very little guidance except the 2014 notice from the IRS and general tax principles. I think a good rule of thumb is the tax basis in an item of cryptocurrency is going to be what you pay for it if you pay US dollars for it, or more generally, your basis in that item of cryptocurrency is going to be the fair market value when you acquire it. Now, with all the advanced technologies, you could probably pinpoint the exact nanosecond when you buy it, and with the volatility in the markets, are you doing it at the beginning of the day? Are you doing it, measuring fair market value at 12:01? Are you measuring it at the end of the day? Who knows? I mean, we just don't know. The message for anybody holding this stuff is you need to know what your basis is. You need to know when you acquire it. Right now, there is absolutely no authority in the tax laws that allows anything other than specific identification of each individual unit of cryptocurrency. There's nothing like first in, first out, or last in, first out, which you see in inventory tax accounting, and there's no cost basis averaging that's available, even though those techniques are available in a lot of other areas of tax accounting. So we need some IRS guidance on that. That gain or loss that I would recognize if I sell my currency or use it to buy a loaf of bread or use it to get my dog, get a rabies shot for my dog, could either be capital, ordinary, or perhaps personal in nature. And that's really important because that's going to drive what tax rate applies to my gain, and it will also determine whether or not I can claim any portion of the loss on a disposition of the cryptocurrency. A capital asset is usually something that's held for investment, which means I buy that Bitcoin with the expectation that it's going to appreciate in value, and at some later point, I'm going to realize that appreciation. If it's capital gains, capital gains are taxed at a 20% rate to individuals or certain trusts and others that aren't corporations. That assumes that I've held the Bitcoin for a year or more. If I haven't held it for a year, it's subject to ordinary income rates as short-term capital gain. If there are losses, if the Bitcoin I used to buy a loaf of bread was a capital asset, and I have a loss on that disposition, there are significant limitations on my ability to take that loss on my income tax return. And I won't go into the details, but you just can't assume that you can use that whole loss. It's possible if somebody is, say, a trader in cryptocurrency, that the gain or loss is ordinary in nature, which means that the 37% rates would apply. And when I say 37, that is the current highest marginal tax rate for individuals. Losses, you would normally be able to take those losses in your trader business to the extent you have income, but there might be some limitations. I think there's a third possibility, which is that Bitcoin is just personal. As a counterfactual, say I'm a video gamer and I like buying these things and it's just fun and, it's entertainment for me. If it's personal in nature, like your house is personal in nature, I might not ever be able to take that loss, and the gains are taxed at ordinary income rates. Somebody goes out and mines cryptocurrency. They're using gazillions of megawatts of electricity, and they mine the cryptocurrency. The IRS position on this is very clear, that when that person receives the cryptocurrency, they have taxable income equal to the fair market value at that time. So at that point, there is an accession to wealth, which is the old phrase for income. It's really important not to confuse an initial currency offering, an ICO, with an IPO for tax purposes. An IPO is tax-free to the issuer under a bunch of special tax rules. An ICO is very clearly taxable to the issuer. So I want to issue a bunch of Bitcoins or something that's really new and different. I expend $100,000 into my project. I capitalize that into the coins. I go out and I sell them for $1 million. I've got a $100,000 basis in the coins that I issue. I have $1 million of receipt on the sale. I've got $900,000 of taxable income. And I'm sorry, I've got $900,000 of taxable income, and I have to tax on that, maybe at the 20% or maybe at the 37% rate. I don't have $1 million then to take onto my business. I have the after-tax amount of that. I am almost out of time, but let me cover the last two things here before I get kicked in the shin. Joe mentioned the lack of anonymity. I think on the tax side, it's really important to realize that a number of the things that go on with cryptocurrency are already subject in general to information reporting requirements. So if you pay your employees with Bitcoin, that employee is still subject to all the normal employment and income tax withholding rules, and you as an employer have to deposit employment taxes. The IRS has made that extremely clear. You cannot deposit those withheld taxes in Bitcoin. You have to deposit them in US dollars. If you pay independent contractors in Bitcoin, there's a 1099 obligation. The penalties for failing to comply with all these information requirements are pretty stiff. They were doubled a couple of years ago, and they are on a per return basis. So if you have lots of transactions using Bitcoin, you can run up pretty steep penalties. Third-party settlement organizations such as credit card intermediaries or organizations like PayPal are subject to reporting under 1099-K, so it's possible that cryptocurrency exchanges could be subject to those. Penalties can get really high under these rules as well. 1099-B, it's not clear whether that would apply in this case, but it's possible. But I think the message here is taxpayers have to keep their own records because they can't rely on the fact that they might get a 1099-B at the end of the year. The last point is really important. The IRS has really been ramping up its enforcement efforts. They have very active criminal enforcement. They track all sorts of transactions. I know from work that I have done that PayPal actually will alert the IRS to suspicious transactions in some circumstances. The IRS has formed a cryptocurrency team. They monitor transactions. They've said publicly that you can't assume that any of these transactions are anonymous. In 2016, they issued a summons to a company called, or an entity called Coinbase, which is a cryptocurrency exchange, asking them to turn over basically all of their records on U.S. taxpayers. Coinbase did not respond. Subsequently, the IRS took them to court, and as a result of the court activity in January or February of this year, Coinbase sent a message to about 13,000 of its customers saying they were turning over all their information to the IRS. That information was supposed to be turned over this month, and I would expect that some of those customers will start hearing from the IRS because they have very significant and sophisticated ways of tracking through people who are avoiding taxes.
Thank you, Kim. Go home and warn your children. And now we're going to talk about the securities laws implications, and Tom Gorman.
Am I pushing here? Okay. This one?
Yep. No.
Nope,
That one.
wrong way. Some of us can't run the clicker very well, so we'll see how this goes. So, the securities laws implications, before we really delve into this, I think everybody with this stuff needs to take a deep breath. And by the way, if you have questions as I'm talking, feel free to raise your hand. I'm happy to talk about it. There's really two themes that you really see when you take a look at this stuff. One is, you heard Joe talk about it, there is this tech, blockchain, ICO, a lot of other tech-sounding kinds of things that has created a frenzy of people buying this stuff. There are literally numerous enforcement cases by the regulators in Washington where they started selling some coin, and within days they had thousands of people buying this stuff, making millions of dollars, and pretty much what happened, what you think happens, happened. Those guys left town. People just threw the money at them, literally. On the other hand, the other theme that you see as you look at all this stuff is, particularly if you're in Washington like I am, there is literally an alphabet soup of agencies that's looking at this stuff. Pretty much every agency in town. You just heard about the IRS. Kim's not kidding. They have a task force. If you don't pay the tax, you can figure out what'll happen. They'll come see you. But there's other agencies there too. The Securities and Exchange Commission, the SEC, who I deal a lot with, they're talking about this almost daily. The chairman of the commission, Jay Clayton, talks about this all the time. The chairman of the CFTC, the Commodities Futures Trading Commission, he talks about this stuff all the time because they have regulatory jurisdiction over some of this stuff. The Department of Justice has brought criminal cases here. The Financial Enforcement Network, FinCEN, they brought cases over for money laundering. The bank regulators are looking at it. All of these regulators are doing the same basic kind of thing. One is they're looking at fraud. The other thing that they're looking at is when these items are sold, tokens, blockchains, whatever you want to call them, and this stuff is not that mysterious. You heard Joe talking about what's a blockchain? It's a spreadsheet. It's a fancy spreadsheet on it with a computer program behind it that automatically updates the thing all the time. It's not a big mystery, but it sounds mysterious, and people throw their money at it. These regulators are going around and they're saying, if that's a security, there's things that you need to do to protect the investing public. And the investing public oftentimes here is not protecting themselves, they're just tossing the money at it. If it's a commodity, you have the same issues. They're trying to take the protections for customers from the commodity statutes and they're trying to impose them on this new investment. And that's the bottom line to all of this stuff. And that's what's going on with all of these regulators. So when you think about the regulators, this is what they're doing. They're trying to wrap customer protections around this because despite the fancy tech names, despite how cool it all sounds, despite the stories that somebody put in a quarter and got back $15,000 tomorrow, which you can maybe do in the lottery too, the fact of the matter is, this stuff is supposed to be an investment. If you're going to invest in the stock market, you want to read the papers. You want to talk to your broker. You want to read what the analysts have to say about this stuff. Try and do that with some of this stuff. You might see the white paper Joe talked about. It's probably 2 or 3 pages. That's about it. Take a look at the paper that wraps around the sale of securities. There's hundreds of pages of stuff with lots of analysts analyzing it, and maybe you're not going to read that, but all that paper translates into the price that you'll pay for it because other people are reading it and they're impacting the pricing. Not so here. Just not so. This is an investment. If you buy Monets because you collect them, it's an investment. Before you buy it, you'll look at the picture, you'll see what it is, you'll look at what the pricing is on the other paintings, and then you decide to buy. That's what this is all about with all of these regulators. There's nothing else going on here. It's not a big mystery. The blockchain, the ICOs, all this other jazz, this is not a big mystery either. This is a product. People are selling it. They want your money. The regulators are trying to protect that, period. That's really all that's going on. So if you think about it from that kind of perspective, then you can sort of walk through and understand what the regulators are doing. So you start with the SEC, my favorite guys, because I deal with them a lot. They've looked at this in 3 areas. And somebody's got to kick me or else I'll forget to change the slides. So we're on the next slide here. This is the SEC. They started off like most people did in this area. They saw this stuff. They saw people selling it. They brought fraud cases. They said, this is a fraud. And take a look at how fast they sold this PlexCorp's case. They brought this stuff out. In 4 months, they signed up 1,500 investors, sold 81 million of these coins, and raised $15 million. And people still have the coins. They don't have the money, and the SEC hasn't found it yet. And that's what's happening if you don't spend the time to figure out what's going on. And the SEC has brought lots of other cases like this. So last summer, the SEC said, enough. There's got to be some protections here for people. You can't just go out and keep selling this stuff. We think, under certain circumstances, this stuff is a security. And if it's a security, you can't just put out a 2-page white paper and say, here it is, go buy some. It's not enough information. It's not enough information to make an informed investment decision. It shouldn't be the kind of way that you want to make an investment decision. So the SEC came up with an analysis. Their report last year basically has a 2-part test here. And it says, look, the question here is, is it a security? There's this 1946 Supreme Court case, the Howey case that everybody talks about, but it's a really fairly simple analysis. If you're putting your money in, and if the idea is you're going to put it into this enterprise of some sort, somebody's selling you this stuff, and they're telling you you're going to get a return on this, doesn't matter what it is, 2%, 10%, 150%, doesn't matter, because the company or the group that you're giving the money to, or whoever it is, the enterprise, is going to do stuff, then it's a security. It's called an investment contract in securities law parlance, but it's no different than a stock. If you buy a piece of GM stock, you're giving them, let's say, $100. The $100 goes into GM. GM makes cars. They sell cars. They make money. They give you some. That's a security. That's what the Howey test is. You look at the economic reality of the transaction. What are we doing here? I'm giving you my money. You're making some stuff. You're giving me some back from the profits. That's the stock. That's the test. It's not really very complicated. It sounds complicated when you talk about 1947 or 1946 Supreme Court cases, but it's not. They developed this in the context of an investigation selling these tokens from what was called the DAO. They're all linked to the blockchain, and it's a virtual currency. And again, when you look at this, you think about this and you say, wow, this is a really complicated process. It's not a complicated process. You're giving your money to these folks, they're promising you they're going to do something with it to make you money, and they'll give you some back. Same as what every other stock promoter does, period. The SEC looked at those facts and they said the real economic interest that's going on here, it's just like the GM example I gave you. It's stock. It's an investment. You want to sell this stuff? File a registration statement and tell people what you're going to do with their money. Or, as you'll hear in a little bit, maybe you can find an exemption from the registration stuff. If you don't do that, we will come and sue you and we'll put you out of business. And that's basically what they do. And if you're not being straight with people, they'll sue you not just for not filing your registration statement, they'll sue you for fraud. Second thing the SEC looks at that is important here is funds, trading. What are you going to do with this stuff? This is a second issue. You've got the first issue, okay, you got to register this stuff. There's a lot of different ways that you can register these interests. There's a lot of different ways that you can get an exemption from registration. But to get that exemption, you got to do things. You got to tell people what you're doing. If you want to put them into, say, your mutual fund, probably a lot of people here own mutual funds. They've got lots and lots of stock in them, things like that. Or maybe an ETF, which is a sort of a variation of mutual funds, because it's just a fund of funds in a lot of senses. Lots of people have applied to put these things, to put currency tokens or virtual currency tokens into these things. And the question is, what are you going to do with them? Other people, like Cameron and Tyler Winklevoss, you may remember them from the movie about Facebook. They had a little fight about who was going to get to run Facebook. They didn't do so well. But they're back. They've got an exchange. They want to trade these things on the exchange. What's happened is the SEC has looked at these things, and on the fund side, they say, okay, you want to put these things in the mutual fund. So mutual fund A has 100 different kinds of stock in it. And every day we tell you at the end of the day, this is how much this thing's worth. Every day, if you want to sell your mutual fund shares, you will get this much money for them based on those valuations. All the money that you're putting in there, we have customer holding rules for brokers who are holding this stuff. We keep track of this stuff so that you're protected. It can't leave town. If you have an ETF, they have processes whereby they can match up the pricing from the net asset value they calculate at the end of the day for the ETF versus what it's trading for on the exchange, because that's the difference between an ETF and a mutual fund, essentially. And there's manipulation issues. So there was a letter sent to the people at the SEC, and they raised all these questions, and I've got shorthand versions of them here on the slide. The question is, how are you going to value this stuff at the end of the day? We've all seen the market prices for this stuff vary, not like the stock market, but take huge swings, and half the time the stuff is completely illiquid and can't be valued at all. And if we can't value it at all, if it's in your mutual fund and you come in and you say, you know, I need to sell the shares today, house payments are due, I need to liquidate this, I need some cash, the fund won't be able to liquidate your shares, and you're going to be unhappy, and the fund's going to be unhappy, and believe me, the SEC will be really unhappy. But how are you going to do that? What are you going to do about the manipulation cases? What are you going to do about the liquidity examples of all of this stuff? It's not stock. It's not something that's readily sellable most of the time. And if you want to take a look at what most of the time may mean, about a month ago, Near Economic Consulting put out a study. They went back and studied how liquid some of this stuff is, and the results are fairly dismal in terms of how liquid this stuff is or is not. There's a citation to that in some of the papers I think that you've got here. But these are questions that the SEC is looking at as to whether or not you can put it in a fund. They're questions as to whether or not you can put it into an ETF. On the ETFs, they've also raised a lot of other questions about the kinds of statements that are being said here, because there really aren't protections that sound like this. A lot of this stuff sounds like it is security, has securities protections, but it's not. And that's part of the problem. And this slide summarizes some of the problems that the Trading Markets Division of the SEC has brought out about how are you going to deal with these kinds of issues so that we can value this stuff so that people are safeguarded and so that there's some sort of readily available value for these investments. And so far, the industry hasn't been able to answer any of these questions. Now, there may well be answers for them at some place, and if they get answered, then the SEC is going to have to come around and take a look at whether or not they're going to let this stuff trade. But right now, nobody's come up with any answers for this stuff, so you can't really readily put these things in there. It all remains off market. This Munchie case, which probably most people have heard about, is a case that's in litigation right now. Joe's going to yell at me when I'm running out of time. I have 5 minutes? Okay. So I'm going to summarize this case fairly quickly. Munchie is a straight up, you should have registered these coins before you went to sell them case. There's no fraud charges here. There's no nothing here other than failure to register. This case is being litigated before an administrative law judge right now, and it may well determine whether or not the SEC's approach is valid. The SEC says they're selling these coins. You promised to put the money into your company, and you're going to raise money for this iPhone app that you were going to invent, and then people would make a profit. That sounds like a security to me. Now, the defense hasn't weighed in with what they've got to say, but I'll point out a couple of things that they could say. The main focus of the Munchie sales and the main thing that they told people was that, in fact, you're going to get profits, but it's not so much from the investment of others. Go back to the GM stock. All those automakers are making cars and selling stuff and getting a profit that you get some of. This is going to increase in value from the ecosystem, which the company defined as more people, more investors are going to come buy this stuff. And when those guys buy this stuff, the frenzy that I talked about at the beginning will continue. And as the frenzy continues, the price will go up. That doesn't sound like you're getting any value out of the company. That sounds like, to me, like you're getting a frenzy out of, or that you're making money off the frenzy that you get from this stuff. I would question whether or not that's a security, but we'll see when the litigation comes out. So, one final point here. This is sort of the SEC's mantra. It's one of my favorite things about them. the chairman of the SEC has given a number of speeches about gatekeepers. Gatekeepers in SEC lingo means market professionals like underwriters, the brokers and dealers, and the securities lawyers who do these offerings. And they have long believed that those people have special obligations to protect the public from fraud. And Chairman Clayton recently said in the speech that's cited in this sample, he said, look, he said, if you take a company and you put we are blockchain in it, there'll be a frenzy for this. But no responsible securities lawyer is going to sell securities based on that frenzy. And if you do, I've instructed the enforcement division to come and investigate you, period. So that's the gatekeeper theory. That's where the SEC is right now. And they are doing these investigations, which I'll touch on at the end, but they are right now doing what I believe is a nationwide sweep. It's not a focused investigation on one company. It's a focused investigation on the industry. And they have issued dozens of subpoenas, and they're going to keep doing that, and they're going to keep looking at this stuff. So let's switch quickly to the CFTC. CFTC has essentially the same mantra here. They look at this from a registration point of view. They look at it from a trading point of view, but they have a different model than the SEC. So from the registration point of view, they decided in 2015 that, in fact, these coins are commodities. And that position was recently upheld in the McDonald case, which we've cited here. It was decided a couple of weeks ago. The court there determined that, in fact, based at least for anti-fraud jurisdiction, not necessarily for registration, that the coins that were being sold were a commodity, and under the definition that they're using, which we have, I think, on the next slide, here in the middle of the slide, the definition that they're using is everything's a commodity. This cup is a commodity if you have a contract for it to sell it in interstate commerce under the amendments that they put into the commodities laws in 2010 in Dodd-Frank. They have jurisdiction over it to bring fraud actions. That's what this case was in the matter, that's the kind of broad jurisdiction that they're looking at. So pretty much everything's a commodity, and it really overlaps with what the SEC's doing. When you flip to the trading side of this, it's different because the commodities exchanges don't have to ask the CFTC if they can trade this stuff. They can do it themselves. They do what's called self-certified. So there are a few products that are trading on the CBOE, on the CME in Chicago. Not too many, but there are a few. So that process is going on with the CFTC monitoring them. And what do I got left now? 2 minutes?
25 seconds.
25 seconds. Okay, 25 seconds. I will tell you the sort of end to the story here. The end of this story is you've got the regulators moving on top, trying to impose these safeguards on people to protect them. You've got the market is still moving and doing different things. For example, one company has now filed a registration statement with the SEC. Query, is the SEC going to let it go effective? We'll see. Cameron and Tyler Winklevoss, who I mentioned earlier, they're back. They couldn't get their trading platform out of the SEC. So now they're over at the CFTC, and they want to create a self-regulatory organization, get away from the agencies, where they can trade this stuff, query whether or not they're just trying to move it one step farther away from the regulators. And maybe the end, or maybe the beginning, we'll see. The social media, which helps promote a lot of this stuff. Facebook announced earlier last week, I think, they're knocking all the ads off for this stuff. No more ads on Facebook. Twitter followed suit and said, soon we're going to take all those ads off. So if social media stops promoting this stuff and the frenzy dies down, ask yourself what you're going to have left when it's done.
Thanks, Tom. Adrian, as our capital markets guy, is going to talk about how you continue to raise money in this unique area.
Yeah, those things.
All right, good afternoon, thank you, I'm really happy to be able to speak with you all today. I'd like to give a little bit of background, because I think it'll help to explain, why I'm here and what my role is. I am a startup lawyer. I started my career in 2000 at the top of the dot-com boom, and I can tell you that, and I'm in Silicon Valley. I can tell you that the excitement that was present at the time of the dot-com boom, with the opportunity, the money, it's back, right? This is a really exciting time. A year ago, I didn't see a single client that was talking about blockchain. Now, I would say 40%, 50% of people walking in the door have a blockchain concept associated with their business opportunity. 2 years ago, it was AI. 4 years ago, it was big data. These things come in trends. But right now, blockchain is hot. And why is it hot? My first slide will tell you why. It's because there's a lot of money going into blockchain startups. Right now, it can be one of the easiest ways to get your startup funded. You can see that in 2017, it went from $18 million in the first quarter to $3 billion in the fourth quarter, for a total of $6 billion into startups. Most of these companies have nothing. They have the white paper that Joe described, right? They may be going a little bit further. They may actually have developed a beta protocol, or they may have some further development. But most of these companies, when they go out, they're going out raising money to create their company. This is a startup financing mechanism, and it's a really interesting one. It's right for certain companies. A lot of companies are coming in, they're saying, I want to be a blockchain company, and you look at their idea, and it really has nothing to do with blockchain. Yes, you can use blockchain, as Tom said, it's a spreadsheet, it's a data source, but if you don't have a fundamental benefit from the fact that you use blockchain over a central database, you've got no business looking at this as being a way to raise money, because you won't be successful, at least not from sophisticated investors. But for those that fit, these ICOs, also now called token generating events, because we wanted to get away from tying it to IPO and keeping Tom busy. These ICOs, 5 times more capital has been raised by startups that have used token generating events or token pre-sales than venture capital investment, equity investment, or the traditional way that startups get funded. And one thing you can see here, earlier you heard there are 4,000 coins. I'm telling you there's 1,600. The truth is, we have no idea. 1,600 are currently quoted. About 1,000 of them have some value whatsoever. The other 600 have really gone down to just about nothing. But there are any number of coins that haven't been reported, or coins that are just part of private pre-sale. So, your guess is as good as ours. We just know it's big, and it's getting bigger. As far as trading, we have some real question as to whether the trading that's going on in cryptocurrency is legal. But there's about 350 billion in market cap in currency right now. And a couple days ago, 18 billion US dollars was traded. So, it is quite vigorous, and it's growing. You all have probably seen or know enough to know that this is the way that cryptocurrency currently looks. It had a spike, it's come down, but not nearly down to where it was before. And it was interesting, a few months back, I took a course on blockchain technology, and we were all watching Bitcoin as it went from 10,000 down to 5,000, back up to 10,000 over the space of about 6 hours. So this is highly volatile. It's a very interesting space, and no surprise then that we have all kinds of specialists that we have to talk to. As a startup lawyer, one of the things that's interesting to me is that when I'm selling equity securities, I don't have to call Tom. I rarely have to call Kim. I don't have to call anybody. It's really simple. When it comes to these ICOs, it's incredibly complicated, right? You have issues of tax. You have issues of SEC compliance. You have issues of foreign jurisdictions. Right now, with the ICOs that we have going on, we're dealing with Switzerland, Singapore, Caymans, Canada, all different structures, all great complexity, all driven by 2 things: the securities laws issues that Tom has just touched on, and the tax issues that Kim has touched on. One of the things we know right now is we don't really have a clue, because everything is developing. And a lot of the opportunities in ICOs right now that you might see are actually token pre-sales. So some of the most successful offerings in 2017 are what are called token pre-sales. And what's happening there is before you even have your ICO, you raise hundreds of millions of dollars from investors on the basis of when I'm done and have developed my protocol, I'll give you a token. Now, one thing everyone agrees, that's a security. No question there whatsoever. It's typically done through something called a SAFT, S-A-F-T, which stands for Simple Agreement for Future Token. Filecoin's a great example of how does this technology actually work in the real world. I've heard a little bit of question as to whether there's valid technology here on my panel, and I'm not sure I entirely agree. Filecoin's a great idea where computers around the world have excess storage capacity. And if you think about those huge data centers that have been put in place over the last 10 years and the amount of social cost, energy, and so on that's used to maintain those, Filecoin's an alternative. It says if you have a computer and you have a hard drive and you're not using all of your space, you can rent that out and you can get a coin for it. Or if you business require the use of additional data, or you want to have it distributed throughout the world in multiple different copies that can't ever be changed, well, here, now you have the ability to do that, and you don't have to set up a data center. You have and so there are some really interesting ideas. One thing that I think is very important from, and I'm speaking very quickly because of time, but one of the things that I think is very important about this slide is look at the categories. They're almost all about infrastructure. They're actually about making blockchain itself work, which is a really interesting observation. You know, when I started this, it all seemed like, you know, it's just people trading cryptocurrency for other cryptocurrency and not actually creating anything of value. We're beginning to see, however, that applications are coming. For example, a recent ICO this year, 850 million, excuse me, it wasn't an ICO, it was a pre-sale, 850 million for a text messaging application. That'll be secure and distributed and all those things. Kodak, as you probably heard, launched a digital asset management for photographers. And they did, when they did that, their stock went up 88%. I mean, just, you know, blockchain's a big deal. And while there's going to be a lot of losers, just like there was in the dot-com boom, there are going to be some winners. And, you know, this is a technology that has specific value from the fact that it's trustless, it's distributed, and it's immutable. Immutable means you can't change it. Once you've put something in the blockchain, it's there forever. If you try to change it, you break the blockchain and you lose all the money that you invested in creating the block in the first place. So, you know, very interesting technology. We won't get into that in great detail, but it's unique. It's very different than a centralized database. As we've discussed, the regulators are beginning to take notice. And boy, it's going to be more and more difficult to market your initial coin offering or your token generating event. Up until now, gosh, it's been the wild, wild west. You go on Facebook, you'll see all kinds of posts. You go on Twitter, you go on Google, you can't avoid people trying to sell you coins, offerings, or pre-sales. And in fact, there are even programs where if you, as a purchaser of tokens yourself, were to go find other people who would purchase tokens in a little bit of a pyramid scheme, you'd get extra beneficial treatment. Those are all going to kind of go by the wayside in 2018 for the reasons that Tom has really talked about. But we should step back and say, what's a token? Why are we even talking about this? Why is it even value? And this slide actually really tells you the difference between yesteryear or the internet craze and the blockchain craze. And it turns out that a lot of the value comes from where is the data stored. So when you think about the internet on the left-hand side, think about eBay. Tremendous amount of value. They collect a lot of data and then they manipulate it. But without things like the HTTP protocol and other protocols that make the internet work, they couldn't do anything. However, those protocols have no monetary value whatsoever. They're essentially free. And all of the value ascribes to the central database where the data is stored. Well, flip side, blockchain, the distributed ledger, all of the data is inherent in the technology itself. And so the belief, this comes from a gentleman named Fred Wilson at USVP, the belief is that the protocols themselves are actually where the value is going to be. And the tokens are your access point to the protocols. That's what makes tokens valuable. It's the fact that you have the ability to do something. For example, in the Filecoin example, you have the ability to store data on somebody else's disk drive. In other cases, you might be able to access specific platforms, have voting rights, have ownership of a digital or a real asset. One of the things that people are talking about a lot is in developing countries, putting real estate onto the blockchain because otherwise records are almost impossible to actually validate. There's a lot of exciting things going on here, and the tokens make that possible. So you can tell I'm bought in. I'm a real believer in this, and obviously there's going to be good ideas and bad ideas and everything in the middle. But let's talk a little bit about what a typical ICO would look like. It's entirely different than the way a standard startup would work. First, we touched a little bit on IP. In this world, IP rights are not particularly valuable. That's because when you put your white paper out, you explain your idea. Beyond that, if you think that you're going to go and file a patent, you're going to have a very difficult time. There are stories that abound of people pitching blockchain ideas and mentioning that they filed for a patent and getting booed off the stage. It's not the environment. This is not what people expect to see. This is collaborative. It's a very unique group of individuals who started the cryptocurrency industry, and some of their unique ways permeate. But in any event, so part of your pre-announcement is you tell the world what the heck it is you're going to do. And so you've got to convince people you're the right team to do it. And you got to explain why, what the pain point is, and how your technology is going to work. But you also separately have to explain the token economics. Why is the token going to be valuable? And this is where Tom gets nervous because those token economics typically read like an investment, right? We're going to enforce scarcity. Tokens don't just keep getting recreated. They can be minted and they can be mined, but generally speaking, there's a limited number of them. That might grow over time, but there's not an indefinite allocation of coins. That's what creates the scarcity that leads to the run-ups that you saw on my slide a few moments ago. So anyway, you do your pre-announcement, and then you start doing token pre-sales. Token pre-sales are done on a contract, oh my goodness, time flies, that are done on a contract called a SAFT. No doubt they're a security. The token pre-sales are typically done with accredited investors and typically done using Regulation D. 506B, if you're your friends, 506C, for those of you who don't know, is the general solicitation version of Regulation D, and it allows you to sell to anybody in the country as long as you can prove they're accredited. 506B allows you, is also accredited investor, but there's a lower standard for making sure that people are accredited. As part of that token presale, you'll typically pull together a PPM. Let me tell you, those PPMs are absolutely worthless. They just have risk factors that are boilerplate. They tend to cross-reference the white paper and the token economics. We try to make them better every time, but it's still something that's being developed. You also have to think about AML, anti-money laundering laws, and KYC. Now, this is something I never had to think about when I was selling stock because the money was coming in from a bank, right? So somebody had already done the AML, KYC for me. But when I'm accepting cryptocurrency to deliver a token, now I have to be responsible for that. And, there are third-party service providers that are coming up and helping assist with completing those tasks as part of your pre-sales. AML and KYC is also relevant at the time that you do your initial coin offerings. So you might raise, in the case of Filecoin, over $200 million in your token pre-sales. You then spend 12, 18 months doing your development. You'll provide all kinds of update and PR to get people excited so that when it's time to do your initial coin offering, you're able to do so. If you're in the United States, it is advisable to think of that as a security, and you're going to need to be thinking about what exemption you're going to use. Typical ones are, again, Regulation D. But the SEC is pushing towards registration. I was at an event where the SEC spoke about blockchain, and they had an hour to tell us everything that they think about blockchain and the developments, and they told us absolutely nothing useful for the private company stuff. But what they did is they spent 50 minutes talking about Regulation A+. Real strong indication that that's one of the ways that they think that that's an answer for the cryptocurrency community. And they really did emphasize that their goal is to work with industry. They understand the value of blockchain, but they also understand the risks that are associated with the way that blockchain has been operating to date. The initial coin offering, fundamentally different than the documents for a typical stock sale. Not a lot of diligence, not a lot of covenants, not a lot of representations and warranties. It's kind of, you see it, you buy it, you move forwards. So why have ICOs risen to popularity so quickly? Well, they've made it possible for anyone and everyone to invest. Now, in the United States, That's no longer the case, or it shouldn't be the case. There's no doubt anymore that the SEC sees this as a security. And any issuer that doesn't take that into account is going to have very difficult days in the future. But outside of the United States, there's still a great deal of uncertainty. In fact, there are a lot of U.S. issuers that are moving south, going to Caymans, and raising all of their money outside of the United States, where they don't necessarily have to comply with all of the securities laws. There are certain aspects that may still apply, but most of those that are most troubling don't. There's a very passionate community of investors. We heard about 81 million raised in 15 months. There are hundreds of millions that have been raised in the space of a couple of hours, right? Ideas that capture the fascination of the world get funded incredibly quickly, usually through cryptocurrency. It takes no time to set them up. If you wanted to and weren't terribly worried about compliance with the law, you can have a coin offering incredibly quickly. It's not hard to create a coin, particularly Ethereum and the smart contracts that Ethereum allows for, makes it very easy to go into business as a coin issuer. They are, at least right now, immediately tradable on online exchanges. There's a lot of complexity that comes out of that I don't have time to discuss here. So just know that's going to change. And here's another thing. For a founder, immediate money in your pocket. Instead of holding your common stock and having to wait for an acquisition or an IPO, you're holding tokens too, and you have something that's tradable. Now, you might put in place some restrictions on that, but you might not. And there's been huge returns. I won't waste time with that. They're huge. So the SEC has said, well, we think these are securities. There was an argument before that we haven't really touched on up here that I'm just going to talk about really quickly, and then I'll stop.
Quickly.
There was an argument before that, well, there are these utility tokens which let you do something, and then these security tokens that are intended to be an investment. Those could actually track to a stock, right, for example, or they could just be for an investment themselves. Like they could have a dividend right or a royalty right. The SEC has just said, we don't believe there's such a thing as a utility token in almost all instances. We think that people are buying these as investments, so whatever you think they are, Filecoin being a great example, you may think that what you're selling is access to somebody else's computer or disk drive, but they're buying it like an investment security, so you should be selling it and providing disclosure like that. That is the informal guidance. We'll have formal coming forwards. What's the practical challenges? So what do I have to deal with on every day? We have a lot of companies that are deciding we're just not going to take U.S. investors. That's interesting, but also problematic, right? When you think about us as trying to lead in the development of technology, if we're not actually investing in it, it can be hard for us to successfully do that. For those people who do use U.S.-based investors, there are all kinds of regulations, not only when they sell the stock, right, using Regulation D or Regulation A+ or S1 and going public or anything like. There are restrictions that say that sometimes you have to hold that stock those tokens for as much as a year. Well, people really like the fact that these tokens are immediately liquid. It causes a little bit of a difficulty when you try to sell. You've heard about the tax planning and structuring. I cannot tell you how many hours I've spent lately talking to Cayman Council and talking to Swiss Council and talking to others, principally just to get away from the fact that when I do a token generating event, there's a huge tax hit. It's hard to raise $100 million and tell your investors that 40 million of it's going to go straight to the tax authorities. And another problem we have is service providers are hard to come by. For a lot of reasons, people are very afraid of blockchain. So we were speaking with the Big Four, and would they ever be an auditor for a company that was a blockchain company? And most of them said, not yet. We're not comfortable. It's hard to find a bank account that'll take your money. It's a challenging environment to operate in. The good news is, for most of my clients, for example, they're in their pre-sale process. They're going to take another 12 to 18 months before they're doing their token generating events. By then, I'm confident they'll know a lot more.
Well, there's just a few issues here. But as you can tell, our team of lawyers have been thinking through these things, and we're going to be here with a little reception after we conclude the program. I'd like to thank the panel and also thank you for attending. You have a great evening.
Very nice.